PLD 2019 Supreme Court 675 Art. 164 Audio tape or video, proving of admissibility in evidence. Requirements for admissibility of an audio tape or video in evidence before a court of law and the mode and manner of proving the same before the court stated. Following are the requirements for admissibility of an audio, tape or video in evidence before a court of law, and the mode and manner of proving the same before the court. I know audio, tape or video could be relied upon by a court until the same was proved to be genuine and not tampered with or doctored. Forensic report prepared by an analyst of the Provincial Forensic Science Agency in respect of an audio, tape or video was per se admissible in evidence in view of the provisions of Section 9(3) of the Punjab Forensic Science Agency Act, 2007. Under Article 164 of the Qanun-e-Shahadat Order, 1984, it laid in the discretion of a court to allow any evidence becoming available through an audio, tape, or video to be produced, even where a court allowed an audio, tape or video to be produced in evidence. Such audio, tape, or video had to be proved in accordance with the law of evidence. The accuracy of the recording must be proved, and satisfactory evidence, direct or circumstantial, had to be produced so as to rule out any possibility of tampering with the record. An audio, tape, or video sought to be produced in evidence must be the actual record of the conversation as and when it was made, or of the event as and when it took place. The person recording the conversation or event had to be produced. The person recording the conversation or event must produce the audio, tape, or video himself. The audio, tape, or video must be played in the court. An audio, tape, or video produced before a court as evidence ought to be clearly audible or viewable. The person recording the conversation or event must identify the voice of the person speaking or the person seen, or the voice or person seen may be identified by any other person who recognized such voice or person. Any other person present at the time of making of the conversation or taking place of the event may also testify in support of the conversation heard in the audio tape or the event shown in the video. The voices recorded or the persons shown must be properly identified. The evidence sought to be produced through an audio, tape, or video had to be relevant to the controversy and otherwise admissible. Safe custody of the audio, tape, or video after its preparation till production before the court must be proved. The transcript of the audio, tape, or video must have been prepared under independent supervision and control. The person recording an audio, tape, or video may be a person whose part of routine duties was recording of an audio, tape, or video, and he should not be a person who has recorded the audio, tape, or video for the purpose of laying a trap to procure evidence. The source of an audio, tape, or video becoming available had to be disclosed. The date of acquiring the audio, tape, or video by the person producing it before the court ought to be disclosed by such person. An audio, tape, or video produced at a late stage of a judicial proceeding may be looked at with suspicion. A formal application had to be filed before the court by the person desiring an audio, tape, or video to be brought on the record of the case as evidence.